Hi, Attorney Steve Fondren. This video discusses what is a complaint. When you hear about people saying, I'm going to file a lawsuit, it usually means they're going to file a complaint. So what is a complaint? What do you need to think about when you're filing a complaint? And let's talk about a few of those things, okay? Now, I'm going to draw this square representing the complaint, okay? So basically, when you feel that somebody has committed a violation of law that has caused you damages, hear me again, when somebody has committed a violation of law that you believe has caused you damages, that's when it's time to file a lawsuit. Now basically, what we normally try to do in a lawsuit is to first send a demand letter. See if you can settle it without having to file a complaint. See if the other party is willing to resolve it. Sometimes a really good demand letter with some case law citing the law applicable to your dispute, sometimes that will compel the other party to settle with you or agree with you to avoid filing a complaint and raising litigation costs. As most people know, litigation is very expensive. Now, in California, if you have a lawsuit under $10,000, you may want to consider filing a small claims lawsuit or small claims complaint. That will save you money and time. It'll be a lot quicker. And we have a video out there called How to Win My Small Claims Case by Attorney Steve. So if you want to Google that in YouTube, How to Win Your Small Claims, you can learn a little bit about that there, okay? But otherwise, let's talk about a complaint. A complaint is basically describing with an introduction what your causes of action are, what the nature of the action is, why you're filing a lawsuit. So basically, I like to put a little short intro, just explaining this is a financial elder abuse case, this is a real estate fraud case, this is a broker's breach of fiduciary duty case. A quick thing that just puts the other side on notice of what your dispute is. Then I'll typically have a section called the parties. And that's where you lay out who are the parties, who are the defendants, who are the people you're suing, where do they live, are they a corporation in California, are they a corporation in Arizona, who are they? So describing the parties. Usually then there's a statement of jurisdiction and venue. You can split those up if you want. Basically, why I'm filing in this court. The court has jurisdiction here under the Civil Code, Code of Civil Procedure, so forth and so on, or the defendant has property here, this is why we're filing here, the venue is here, the defendant resides here, those kinds of things. So you're giving reasons for the jurisdiction and the venue. Next, we'll get rid of these things here. Next, we're talking about setting forth our general allegations, okay? What are these? These are the things you are alleging, okay? 1, defendant is a resident of blank. 2, defendant took my money. 3, blah, blah, blah. So you're laying out all your allegations and setting forth all the reasons why you're filing this complaint, okay? And generally speaking, you want to put out those facts that you're aware of, okay? And when I say facts, you try to stick to the facts. The sky was blue. It was 10 o'clock a.m. On this date, 12/15/2014, this is what happened. This person talked to that person, so forth and so on. So you want to get your allegations out there to let the other party know the facts that you have at hand. Now, you don't always have all the facts. Sometimes you are missing facts, but you know, or you have a strong belief that you will obtain the facts when you go through a discovery process. Discovery being the part where you send written requests for information, seeking documents, requests for admissions, special interrogatories. Those are other things that we'll discuss in our discovery modules, okay? But for now, you're putting down all the facts that you know. Just line them up, 1, 2, 3, 4, and put them down in a line, okay? And so the things you don't know, you can allege on information and belief, okay? On information and belief. That means you have a suspicion based on a belief, or you have a belief or a suspicion, and that you believe upon conducting discovery, you're going to be able to prove that, okay? Now, these are the things that I want you to think about in regards to your general allegations, okay? The one thing I want to tell you is, in general, when you're thinking about writing these complaints, California and Arizona follow what's called a notice pleading jurisdiction. What does that mean? That means your complaint really doesn't have to be a manifesto on every possible thing that could have ever transpired in the case, but it needs to put the other party on notice of what your dispute is, of what your complaint is. Okay, so it's called a notice pleading jurisdiction. So that means put down enough so that the other party knows what the problem is, how to defend. Okay, and so it's a notice pleading jurisdiction. Keep in mind, however, and I have seen this a bunch of times, even in my own cases, that notwithstanding the fact that it's a notice pleading jurisdiction, you'll file your complaint and the other side will file a demurrer. Okay, and we'll talk about that in another video. A demurrer. In Arizona, we call it a motion to dismiss. Okay, and oftentimes these two documents that will be filed by your opponent, the defendants, will oftentimes tell the court that all this person is alleging is conclusory allegations. It's just conclusory. There's no facts, Your Honor. They're not pleading with specificity. They're not being specific enough. So my advice is to try to really hone down on the details, throw down what you know, and also bearing in mind that the more you throw down, when you get a discovery request from the other side, they could very well go down and ask you, give me all your facts supporting number one. Give me all your facts and documents supporting number two. Give me all your witnesses supporting number three. So, you know, there's this fine line, and this is the art of drafting a good complaint, is having enough to put them on notice, having enough to overcome these demurrers and motion to dismiss, these initial pleadings that could be filed, and basically spelling out your complaint in clear and specific terms. Certain things like fraud, you need to plead with specificity. We'll talk about that in a second. So that's a general concept of the complaint. Now, the final part of your complaint, not the final, but pretty much after your general allegations, okay? After your general allegations, you're going to want to put your causes of action. Okay, in Arizona, sometimes they call these counts. Okay, your counts. Count one, count two, cause of action number one, cause of action number two, cause of action number three. So you're spelling these out, okay? Number one, boom. Number two, boom. Number three, boom. You're spelling these out. So let's give you an example. So say somebody hits you, okay? In most states, in a battery is defined as an intentional infliction of a harmful or offensive bodily contact. Okay, that's just law school 101. We get that back from first year law school. An intentional infliction of a harmful or offensive bodily contact. Okay, so what do? There's your law. Okay, this is your law. Now you're trying to plead your cause of action and basically informing the other side how they violated the law. Okay, and so you do this by taking your facts and applying it with your law. Blank, blank, blank. And a lot of times here, you're going to incorporate your allegations in the preceding paragraphs. Usually there's going to be a little clause here that says, plaintiff incorporates the foregoing allegations set forth in paragraphs number 1 through 80 as though set forth fully herein. As though set forth fully herein. And so you start doing this, and I'm not saying always, but normally that's what you're going to see. So here you say, you know, on December 3rd, 2013, you know, he came up to me, he clenched his fist, he reared back and said, I'm going to sock you good. And he socked me there in the jaw, pushing my head back, making me fall back and make contact with the counter, causing severe head trauma and injury. The contact was intentional. He intended to hit me. It was harmful in that it caused me bodily damage. It was offensive. to a reasonable person and was offensive to me as all my friends were around, and it caused me $50,000 in medical bills. So that's how you want to do a cause of action. And then you may want to add, wherefore plaintiff seeks his medical bills, whatever remedies you're entitled to get under the law. Okay, the remedies you're entitled to get under the law. That's what you want to be thinking about. So all you're really doing then is you're taking all your allegations and you're setting them forth 1, 2, 3, 4, 5. So you need to go and research the law and know what the legal grounds are, know why you're disputing what their causes of action are. You may have several. You may only have one. You may have 20. Okay, some lawyers will say, you know, throw everything against the wall and see what sticks. You could do that, but really you want to file things where you have facts and law to support your cause of action. Otherwise, somebody could sue you for malicious prosecution. They could say you're abusing process. You could be subject to the motion to dismiss and the demurrer. You could spend more money than you actually have to spend. So what I like to do is try to find only those cause of action where you really think the facts and the law apply to your circumstances. Make sure you know what the remedies are that you're entitled to, and then go seek those. But put as many causes of action as you have and put those down. And then a final section of your complaint would basically be, and I dropped my eraser at the critical moment, the final piece of your complaint would be what I call a prayer for relief. Prayer for relief, okay? Put that down. Based on the foregoing, for the first cause of action, I seek blank. For the second, I seek blank. For my third cause of action, fraud, I seek blank. Let the court know what you need. Sign and date it, and there you go. So that's your basics of a complaint. And then, of course, when you have the complaint, you're then going to serve it. You're going to serve it with a summons, and the summons is going to be stamped by the court. So you're going to serve the summons and complaint on all the defendants that you named in your action. So again, you also want to think about, there's a fine line between suing everybody under the sun, which could potentially create a gigantic discovery fiasco for you, where papers flying everywhere and you're totally swamped, to, you know, you want to make sure you're filing the right parties. As part of that, you normally want to see that you're suing a party that actually you have a reasonable means of collecting from, because, you know, you've heard the saying, getting a judgment it's as good as the paper that it's written on. So you may want to make sure you're suing the proper parties, the right parties that have actually done you harm, and parties that you can actually seek to collect from. You don't want someone that's quote-unquote judgment proof. Okay? So that's the basics of the complaint. After that's filed, you're going to get the summons and the complaint together, usually a cover sheet, usually an arbitration notice. You're going to file that with the court. You're going to pay your filing fees, and then you're going to serve your packet. Serve that packet on all your defendants. And we'll have another video on personal service of process. So check our website, vondranlaw.com. We have more information there in our Litigation Warrior library. So I hope this has been helpful. This is your general lawsuit. When people talk about filing a lawsuit, filing a complaint, these are the general things to be aware of. Okay? Hope this helped. Have a great day. Don't forget our small claims suit. If you have small claims, it may benefit you to go to a small claims court where the process is similar, but a lot shorter. You'll get to a trial or a hearing quicker, and you can actually collect a decent amount of money. So check that out, and we hope you are successful in what you're doing. If you need any help, give us a call, 877-276-5084. We can help in civil litigation matters, business and real estate law. Attorney Steve, this is what we do. Thank you for listening. Check us out at vondranlaw.com. Have a great day.